provisions of Chapter 16 of the Constitution. I will now move to the second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment and popular initiative route provided for under Article 257 of the Constitution. Like other non-producing process, a constitution amendment process starts with an initial decision, that is the initiation or activation of the process. The initiative speaks to how the amendment process starts. The story starts with the 8th August 2017 presidential elections, in which the President was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the presidential elections. The Supreme Court annulled the results through a majority decision delivered on 1st September 2017 and ordered fresh presidential election to be conducted within 60 days of the nullification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, withdrew from participating in the fresh presidential election, which took place on the 26th October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence that brought about tension in the country. After months of tension, the President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that there was cessation of hostilities between the two political sides in what they called a handshake, through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10 January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the Building Bridges to Unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that institution of the presidency has the authority to initiate a popular initiative in light of the overarching leitmotif of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the president with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255, 3b of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This brings me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the President and even the Attorney General sustained an argument that barring the President from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the President's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional angle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the President, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the presidency, which is a state organ. The presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed who are the initiators and promoters of the impugned constitutional amendment initiative and not the President. An examination of the evidence before the courts reveal a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray his role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018, the official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the President was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the President of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with words 360. Clause 1(2) of the second schedule proceeded to distribute the additional 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule, directly allocating and apportioning the proposed constituencies to specified counties, were challenged. The two superior courts were unanimous in their findings that the second schedule to the amendment bill was unconstitutional. This finding was based on the substantive grounds that the second schedule violated the basic structure of the Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IEBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure and doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with the second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IEBC, an independent constitution commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the potential of diluting the power of the votes, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4.2 and 10.2a of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government's Constituency Development Fund and the recruitment into disciplined forces such as the Kenyan Defence Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10.2b of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenyan bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10.2 of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020, in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as considered in the President's written submissions filed before the High Court, there is a public element in this matter, So this court should clarify and settle the law on the nature and scope of protection of the president from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relate to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted against the president or a person performing the functions of that office during the tenure. From the structural reading of the above provisions, there are glaring distinctions that illuminate the nature